Hello, everybody. Welcome to iExamBee's LegalBee. This is Amrita, your law faculty here at iExamBee. Embrace the iExamBee learning experience with us. And if you're preparing for any competitive examinations after your law, like SEBI Grade A Legal Officer exam, IBPS SO Law, IBPS RRB Law Officer exam, various other examinations like these, then don't forget to subscribe to LegalBee. LegalBee keeps on providing you various content and strategic videos relating to these examinations, and also ऑनलाइन कोर्सेज आर अवेलेबल ऑन iExamBee's वेबसाइट. इन कोर्सेज के आप डेमो एक्टिवेट करके चेक कर सकते हैं. कोई भी क्वेरीज हो, रीच आउट टू अस बाय राइटिंग अस एन ईमेल ऑन hello@iexambee.com or call us on the number 920-552-4028. Download our app from the Google Play Store for 50% faster job preparation. I've started a series for SEBI Grade A Legal Officer exam preparation. This is containing 300 most important MCQs. My today's video is the sixth part of the series. अगर आपने बाकी के videos miss कर दिए हैं, then do check it out in the playlist of LegalBee. In part 6, I'm going to continue with Contract Act, some more questions. First, which of the following is an exception to the concept that agreements by way of wager are void? Keeping lottery office, any sum of money to be awarded for any horse race, sum of money of the value or amount of 500 rupees or upwards to be awarded to the winner of any horse race. All A, B, C, either A or B. So इनमें से कौन सा एक्सेप्शन है? कंसेप्ट की वेजरिंग अग्रीमेंट्स वॉइड होते हैं, इसके रिलेटेड काफी फेमस टॉपिक है ये. क्वेश्चंस आने के चांसेस हैं यहाँ से. करेक्ट आंसर इज सी. Sum of money of the value or amount of 500 rupees or upwards to be awarded to the winner of any horse race. So ये horse race से related है. Section 30 covers this. Agreements by way of wager are void. But if you will look into it, they have covered this exception in favor of certain prizes for horse racing. Section 74 of the Contract Act lays down provisions relating to compensation for breach of contract, where penalty stipulated for, penalty specified for, penalty stated for, penalty non-stipulated for, penalty as the court may decide. So compensation of the breach of the contract is covered under section 74. But penalty के बारे में क्या status है? Correct answer is A. Penalty is stipulated for over here. Compensation for breach of contract, where penalty is stipulated for when a contract has been broken and the sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount named for, as the case may be, the penalty stipulated for. So reasonable compensation दिया जाएगा and that will not be exceeding the amount named or the penalty stipulated for it. As per Contract Act, what is the liability of a person to whom money is paid or a thing is delivered by mistake or under coercion? Must repay it, he must return it. Parties have the right to mutually decide and agree upon the same. No liability is there on his part as delivery was made by mistake or under coercion. Either A or B are correct. Correct answer is last only, A or B. Section 72 covers this liability. Liability as to person whom money is paid or thing is delivered by mistake or coercion. But he must repay it or he must return it. It is his liability. Even if it has come under mistake, he should not take benefit out of it. When should a person be reimbursed for paying money which is due to be paid by another? When the person who has made the payment has interest in the payment of money. When the person for whom the payment has been made has interest in the payment of money. When the court directs the party to make such payment, where there exists any liability of the person who is making the payment for another. When the parties mutually agree upon such payment being made. So when should a person be reimbursed for paying money which is due to be paid by another? Which of the following conditions? Correct answer is A, when the person who has made the payment has interest in the payment of money. Section 69 talks about reimbursement of person paying money due by another in payment of which he is interested. A person who finds goods belonging to another and taking them into his custody is subject to the same responsibility as a dash. This is about finder of goods. फाइंडर ऑफ गुड्स बहुत अच्छा इंपॉर्टेंट टॉपिक है कॉन्ट्रैक्ट एक्ट से. फाइंडर ऑफ गुड्स की लाइबिलिटी सेम होती है जो एक बेली की लाइबिलिटी होती है आफ्टर बेलमेंट. सेक्शन 71 टॉक्स अबाउट द रिस्पॉन्सिबिलिटी ऑफ फाउंडर ऑफ गुड्स और फाइंडर ऑफ गुड्स. सो उनकी सारे की सारी लाइबिलिटी बेली की तरह होती है, राइट्स एंड लाइबिलिटीज दोनों भी. Ankit, a tradesman, leaves goods at Sushil's house by mistake. Sushil treats the goods as his own. Sushil is bound to pay Ankit for them. Sushil is not bound to pay Ankit for them. Sushil might have to pay Ankit if the court decides so. Sushil might have to pay if both the parties agree so. He has no obligation towards Ankit as it was Ankit's fault. Which of the following correct answer you find over here? By common logic, also we can say that he's bound to pay Ankit for them. Obligation for person enjoying benefit of non-gratuitous act, because the act is not gratuitous. Gratuitous. It is non-gratuitous. Means there is an act which is not being committed out of gratitude, that you are taking the benefit or enjoying the benefit of it. If it is out of natural love and affection or gratitude, that is a different thing. But if he has by mistake left that thing, it is your responsibility to return it or pay for it. As laid down under Contract Act, what is the effect of refusal of a party to perform a promise wholly? Promisee may put an end to the contract. Promisee may claim specific compensation. Promisee may give his acquiescence in its continuance. Either A or B, either A or C. So, what is the effect of refusal of a party to perform promise wholly? The correct answer over here is E, either A or C. Promisee may put an end to the contract, or promisee may give his acquiescence in its continuance. So, this is also specifically covered under section 39. यहाँ से directly ये question pick किया गया है. What is the effect of promisee accepting the performance from third person as per the Contract Act? He can afterwards enforce it against the promiser. He can afterwards enforce it against a third person. He cannot afterwards enforce it against the promiser. He might get it afterwards enforced against the promiser. It is at the discretion of the parties to the contract. What is the effect of promisee accepting the performance from third person as per contract? Correct answer is C. He cannot afterwards enforce it against the promiser. Section 41, effect of accepting performance from third person. When a promisee accepts performance of promise from a third person, he cannot afterwards enforce it against the promiser. Sonali promises to paint a picture for Karishma. The performance of the promise can be by Sonali personally, by anyone Sonali may employ, by Sonali's legal representative, either A or B or C, either A or C. So, promising to paint a picture, that has to be performed personally or it can be delegated to someone else. Correct answer is A only. It's very clear that it is an art which Sonali personally has to do. She cannot employ someone else to do it. She has promised it for performance of contract. She has promised that she will perform that particular act. Section 40, person by whom promise is to be performed. If the nature of that particular activity is such that it has to be done by that person himself or herself, then they have to do it on their own. As per Contract Act, where should the payment be applied in case the debt to be discharged is indicated by the debtor either with express intimation or under circumstances implying its application? It should be applied in discharge of the debts in order of time. It should be applied to the discharge of some particular debt. It should be applied to any lawful debt actually due and payable to the creditor from the debtor. Be applied in the discharge of the debts proportionately as the creditor and the debtor may mutually agree upon. So, as per Contract Act, when we are talking about the payment applied in case the debt is to be discharged and that is indicated by the debtor either with an express intimation or under circumstances that are implying its application. In that case, the payment should be applied to the discharge of some particular debt. Section 59 talks about this application of payment where debt to be discharged is indicated. Where should the payment be applied in case the debt to be discharged is not indicated as per the provisions laid down under the Contract Act? It should be applied in the discharge of the debts proportionally. It should be applied to the discharge of some particular debt. Debtor may apply it as at his discretion to any lawful debt actually due and payable by him to the debtor. Either of the parties may decide the application of the debt to any lawful debt actually due and payable. Creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor. So answer is E, section 60, application of payment where debt to be discharged is not indicated. So in the previous question what we have discussed, that it is indicated. So the correct answer will be that it will be applied to the discharge of some particular debt. But now in this question, what they have asked you, we have given you both the conditions in these questions so that you can be very clear. इनमें से अगर आपको एक चीज पूछी जाए तो आप कंफ्यूज नहीं होंगे. You have to see whether it is indicated or not indicated. Application of payment where debt to be discharged is not indicated. In that case, the answer will be E. Creditor may apply it at his discretion to any lawful debt actually which is due and payable to him from the debtor. Any lawful debt they can apply. Where should the payment be applied in case neither party appropriates the application of the debt as provided under the Contract Act? It should be applied to the discharge of some particular debt. It should be applied in discharge of debts in order of time. If the debts are of equal standing, payment be applied proportionally. Either A or B or C, either B or C. So when in this is the situation now, this is again a type of similar question, but there is a change where the payment is to be applied in case neither party appropriates the application of the debt. Then in that case, either B or C is going to be your correct answer. That is, either it will be applied in discharge of the debts in order of time, or if the debts are of equal standing, payment will be done proportionally. Section 61, application of payment where neither party appropriates. If the parties to contract agree to substitute a new contract for it or to rescind the contract or alter it, the original contract may be performed. Original contract need not be performed. Original contract remains valid. All the parties may enter into another contract. Original contract is non-extinguishable. Parties have the discretion to decide upon the same. So in this case, ओरिजिनल कॉन्ट्रैक्ट पे क्या अफेक्ट होगा अगर पार्टीज न्यू कॉन्ट्रैक्ट सब्स्टिट्यूट करते हैं, रेसिंड करते हैं या ऑल्टर करते हैं. सो द करेक्ट आंसर विल बी ओरिजिनल कॉन्ट्रैक्ट नीड नॉट बी परफॉर्म्ड. Effect of novation, rescission and alteration of contract covered under section 62. What is the obligation of a person who has received advantage under void agreement or contract that becomes void as per section 65 of the Contract Act? Person is bound to restore the advantage so received. Person is bound to make compensation for it to the person from whom he received it. Person is not bound as such, as it is a void agreement or a contract that becomes void as the case may be. Either A or B. Person will be bound for the contract that becomes void, but not bound for the void agreement. So here we are talking about obligation of a person who has received some advantage under a void agreement or a contract, and that has become void as per section 65. What about his liability or obligation? Answer is D. A or B, both can be done. Either person is bound to restore the advantage so received, or person is bound to make compensation for it from the person from whom he has received that benefit. Section 65 talks about this obligation. Which section of the Contract Act deals with the provisions of effect of neglect of promisee to afford promisor a reasonable facilities for performance? Section 7, 17, 37, 57, 67. सो यहाँ पे हमने सेक्शन बेस्ड क्वेश्चन भी एक हाथ दो मैंने डालने की कोशिश की है बिकॉज आपको उसके लिए भी प्रिपरेशन होनी चाहिए. कौन से इंपॉर्टेंट टॉपिक्स है, कुछ कुछ प्रोविजंस भी आपके दिमाग में रहने चाहिए. यू कैन रिमेंबर, इट इज इम्पॉर्टेंट. Section 67 covers this effect of neglect of promisee to afford promisor reasonable facilities for performance. If any promisee neglects or refuses to afford the promisor reasonable facilities for the performance of his promise, then the promisor is excused by such neglect or refusal as to any non-performance caused thereby. So if there is such kind of thing, then he is excused. The promisor is excused over here. What are the consequences of rescission of voidable contract as per Contract Act? Other party is bound to fulfill his respective obligations under the contract. Other party need not perform any promise therein, contained in which he is the promiser. The party rescinding a voidable contract shall, if he has received any benefit from the another party to such contract, restore such benefit so far as may be to the person from whom it was received. Both A and B are correct. Both B and C are correct. So, rescission of a voidable contract, if we are talking about what are the consequences of rescission of a voidable contract? Answer is E, that is both B and C. Other party need not perform any promise therein contained in which he is the promiser, and the party rescinding a voidable contract shall, if he has received any benefit from the another party, restore that benefit. Section 64 talks about this. Rescission of voidable contract may be communicated or revoked in the same manner and subject to the same rules as apply to the communication of a proposal, revocation of a proposal, communication of an acceptance, either A or B, either A, B, or C. Correct answer is E. Section 66, mode of communicating or revoking rescission of voidable contract. The rescission of voidable contract may be communicated or revoked in the same manner and subject to the same rules as apply to the communication or revocation of a proposal. Contingent agreements to do or not to do anything if an impossible event happens are void when the circumstances imply that the event is impossible. If the impossibility of the event is known to the parties of agreement, possibility of event is known to the parties to the agreement, whether the impossibility of the event is known or not to the parties of agreement when it is made, and same thing, event it is known or not to the parties to the agreement if it is impossible. D option और E option में सिर्फ इतना ही फर्क है, possibility of event and impossibility of event. Correct answer is the last one. If the impossibility is known or not to the parties to the agreement at the time when it is made. Section 36. If there is an alternative promise where one branch being illegal, then the legal branch alone can be enforced. Illegal branch might not be enforced. Either branch may be enforced at the discretion of the parties. Either branch may be enforced at the discretion of the court. Entire promise is considered to be an illegal promise and thus it will be void. So if there is an alternative promise where one branch is illegal, then in that case, correct answer is A, the legal branch alone can be enforced. We can segregate and enforce it. Section 58 covers alternative promise, one branch being illegal.